So at the Sierra Crest Business Law Group, we do represent beneficiaries in contested estates. And I would say the number one situation that frustrates beneficiaries the most is when the person in charge is not communicating. And the good news is that there are statutory rights that you as a beneficiary have to information about the estate. And it breaks down into two things. One is you are entitled to know what property is in the estate. And you're entitled to ask for and receive what's called an inventory, that's the list of the property and the value. And the second thing is you are entitled to know what's being done with the property in the estate, and that's called an accounting. And you can demand an accounting and get it, and if you don't get it, you can go to court and ask the judge to compel that. And the person who is sitting in the seat of the trustee or the executor has to respect your rights to the information and give you that information. I think the one key that will tell you when you need to seek legal counsel is when you're asking questions of the trustee or the executor and you feel like they're dodging your questions or ignoring your questions. When the information is constricted like that, that's when you know you need to get legal counsel to not only get the information, but to figure out why they're dodging or evading you. So as a beneficiary, you have rights under the probate law. You have the right to information about what's in the estate. You have a right to an accounting of what the trustee or executor is doing with the property of the estate. And you have the right to see to it that the instrument, the will or the trust, is being followed correctly. And if there is no will or trust, that the statute, for intestate succession is being respected. And you have the right to know that the trustee is performing their duties and not wasting away the property of the estate. And on all these things for which you have rights, you have the right to be heard by the judge. So no matter what the situation, good communication is always going to lessen or at least bring a trust dispute into focus. If the beneficiary, for example, has good information, they can see, oh yeah, the trustee or executor, they are doing their job, and I can have confidence that they're following the right process. Or they can see there have been some missteps here that need to be rectified. Some property was disposed of incorrectly, or the trustee converted property to their own benefit, and we need to, get this back in track, and we need to address this and make this right again. So I think the number one mistake that you can make as a beneficiary in a contested estate is to sit back and do nothing, because you need to understand that the estate process will continue to grind forward, and there are tight deadlines and opportunities to object to what's going on. And if you sit back and do nothing, you basically are saying yes and agreeing to what is being done. So that's the number one mistake. I think closely followed by that, the number two mistake would be to fan the flames of emotion and heat within the family rather than, proceed in an orderly manner, get an attorney to address the specific issues, according to the law, without stirring up a big family fight in the process. The attorney can say, this is what you're entitled to. We're going to write them a letter. We'll get what you're entitled to. And it's a direct process as opposed to the process of stirring up a huge dispute within the family. So if you're the beneficiary of an estate, especially a contested estate, your number one priority is making sure that the estate is administered according to the law, that it's fairly handled, and that you're informed every step of the way of what is happening. If you have any questions about how to get that clarity and how to get that enforcement, give us a call at the Sierra Crest Business Law Group. We'd be delighted to talk with you.